Good morning. This is the third session of the Kansas Court of Appeals this morning. Today, the panel includes Judge Sarah Warner, who has been with this court since 2019, and Judge Leslie Ann Isherwood, who has been with this court since 2021. And myself, Kim Schroeder, I am the presiding judge, and I have been serving on this court since 2013. My job as the presiding judge will be to kind of keep track of time. I'm not always a great stickler on time. I note that this case is set for 20 minutes. Before we begin the case, I would like the appellant to take a few minutes, and I won't count it against you, to give some factual background of the case, since we're being recorded on YouTube, so that if anyone is listening, they'll have some understanding of why actually this case is before our court. This is in the Prairie Wind LLC versus Reno County, Kansas, and the Board of County Commissioners of the County of Reno. It's case number 123277. Counsel, I'd ask for you to reflect your appearances.
Timothy Sear on behalf of the plaintiffs, appellants.
Eric Steinley of the law firm of Martindale, Swear, Schaefer, Ridenauer on behalf of Appalese, Reno County, Kansas, and the Board of Commissioners of the County of Reno.
Patrick Hughes of the Adams Jones Law Firm in Wichita on behalf of the intervener in Appalese.
All right, and has there been an agreement among counsel as to how you're going to split time?
Yes, Your Honor. It would be my goal to split it equally and take no more than 10 minutes. If I should use less than 10 minutes, I'd like to yield that to Mr. Hughes.
All right. And Mr. Sears, you are the appellant. Are you asking for time for rebuttal?
Yes, Your Honor. I would request 10 minutes for rebuttal.
So you want 10 and 10?
Correct.
All right. Just make sure I'm understanding the issues correctly. All right, then, counsel, you may proceed.
Your Honor, to give our viewers a brief overview of the factual background of this case, the plaintiffs in this case were applied for a conditional use permit to construct and operate a wind farm in Reno County, Kansas. Under the Reno County ordinances, a conditional use permit is required for this kind of activity. A conditional use permit application goes initially to the County Planning Commission, and then following a recommendation from the Planning Commission, that application proceeds to the County Commission, which is the governing body of the county. The County Commission is a 3-member county commission. Under the zoning laws of the state of Kansas that apply both to municipalities and to counties, if a certain percentage of the property owners that are under the statute to receive notice of the application for the conditional use permit execute a protest petition that is properly executed and filed with the county clerk, that protest petition triggers a requirement that the ordinance or resolution of the county commission that might otherwise approve the conditional use permit must be passed by a 3/4 majority vote of the governing body. Using very high level math in this situation, where you have only a 3-member commission, that would require unanimity of the commission, because 2 of 3 votes of the commission would only constitute 66% of the governing body. So if a protest petition is effective, the 3/4 requirement under the zoning statute triggers a requirement of unanimity of the 3-member commission. In this particular instance, 2 of the 3 commissioners voted in favor of granting the conditional use permit. And so absent a valid protest petition, that resolution or ordinance would pass by a 2-to-1 vote, and the conditional use permit would be granted. However, in this case, the district court determined that the protest petition was sufficient, triggering the 3/4 majority vote requirement, and therefore the application was defeated by only obtaining 2 of the 3 votes of the commissioners, not the 3rd vote. Now, the only issue that we believe is properly before this court on appeal.
Counselor, can I ask a question? How big of an area does the protest notice require?
Your Honor,
is it a 3-mile range?
I don't have that directly.
All right, I didn't see it in the briefing, and I was just curious. I can find out myself.
There is a statutory requirement of what the notice area is that surrounds the area that is the subject of the application. And in this case, no one claims that was improperly calculated, or that those persons entitled to notice and the opportunity to file a protest petition were not given that notice and that opportunity. Okay. The only issue that is properly before this court in this appeal is the issue of whether or not the signatures of the circulators were required to be notarized pursuant to the provisions of KSA 53501. Now, there was no mention in my overview of the case of circulators. Under the Kansas statutes, KSA 253601 et sec, it provides that under any situation under Kansas law where a petition is allowed to be filed, that either the petitioner can file the petition, or a person identified in that statutory scheme as a circulator can obtain the signatures and file the protest petition. In this particular instance, if all of the protest petitions that were filed by circulators are invalidated, which we believe that they should be, then there were not sufficient non-circulator protest petitions filed to trigger the supermajority requirement that required 3 of 3 commissioners to vote.
Counsel, I want to just clarify for my purposes here. If we decide that substantial compliance was achieved in this case with regard to the statement of the circulators, would you agree that then the case is over from your perspective?
Well, Your Honor, if this court determines that substantial compliance is the test to be used in this situation, that would be the application of an incorrect test.
I understand your argument. I'm just trying to figure out, getting to kind of the bracket of all of these arguments. If we disagree with you and we decide contrary to your argument there, if we decide that substantial compliance is sufficient and that these petitions or this petition substantially complied with the statute, would you agree that because you have consented to judgment that's the end of the case?
Well, that would end the case, Your Honor. There is no consent to judgment in this case. This red herring that somehow there was invited error in this case simply has no basis in fact. That is, once the court entered its order on partial summary judgment that the petitions were valid and triggered the supermajority vote, there was no reason to proceed to any sort of evidentiary trial on that, because the district court determined that as a matter of law based upon uncontroverted material facts.
And I just want to make sure, so then, I mean, you're not arguing from an evidentiary standpoint, you're not going to come back and challenge these individual petitions, despite the fact that there's some deposition testimony, et cetera, that was pointed out in your briefs. You're not challenging the individual statements by the circulators. You're just challenging the petition as a whole.
That's correct, Your Honor. We had other counts in the appeal as filed, and we dismissed those claims after the court found on summary judgment that the petitions were valid. And at that point, when we dismissed the other counts of that appeal, there was nothing further before the court. And so, based upon a stipulation of counsel, of all the county and the interveners signed off on the proposed judgment to present to the court, in order for the decision of the court on the circulator issue to become final and appealable, then that created the final judgment that went to this court.
Can you help me understand, counsel, why this circulator statute applies at all?
Well, Your Honor, because the language of the statute is broad enough and specific enough to include this. That is, if you look at 253601, it refers to that if a petition is required or authorized as a part of the procedure applicable to the state as a whole, there's no doubt that the zoning ordinance, the zoning statute 12757 applies to the state as a whole. And there's no doubt that 12757 refers to a type of petition, a protest petition. So that fits squarely within 253601. Now, I would also point out to the court that issue is not before the court on this appeal. The plaintiffs, the district court ruled in favor of the plaintiffs that 253601 does apply to protest petitions, and there was no cross appeal filed in this case. So there is no basis for either the county or the interveners to raise that issue on appeal without having already filed a notice of cross appeal.
Counsel, you addressed that in your opening brief, however, didn't you?
Well, we've laid out what it is that the district court did and how the district court ruled. But in order for the appellees to claim that the district court incorrectly ruled that the protest, that the circulator statute applied, they are required to file a notice of cross appeal. There's just no ifs, ands, or buts about that issue, and they failed to. Now, I would also point out, Judge Warner, relative to your question of why, does 253601 apply? Look at subsection C. In subsection C, both the term petition and protesting is in the same sentence. The form of any question in a petition requesting an election or protesting an ordinance or resolution adopted by the governing body. That, again, squarely applies to this case. That is, if there is a valid protest petition, then an ordinance or resolution approving the conditional use permit application cannot be given legal effect if there is a valid protest petition.
Counsel, are you aware of any instance other than the persuasive authority that you've cited in your brief? Are you aware of any instance where our court or the Kansas Supreme Court has applied the petition provisions in 253601 to an instance that doesn't require a question to go to the electorate, but rather requests an action by a government body?
Well, there is a reference to this statute in the unpublished Deffenbaugh decision. Now, I certainly will acknowledge that the Deffenbaugh decision dealt with this issue in a very cursory manner, but nonetheless, it was a zoning issue calling for the application of KSA 12757. And of course,
and I agree that case made reference to and in fact incorporated this statute. But I'm just curious because I didn't find anything. Did you find anything else where either our court or the Kansas Supreme Court has applied this broadly to something that doesn't require a decision by the electorate?
Well, Your Honor, there is a dearth of case law on this statute, period. There simply is not much to be gleaned from this other than the clear language of the statute. And of course, not to be too repetitive here, but that issue is not before this court because there was no cross appeal filed on this. And I would point out,
Counsel, I've allowed you to exceed your 10 minutes here a little bit, so I'll let you draw it to a close and reserve your rebuttal time.
Okay. One thing I would like to point out in this opening round, Your Honors, is that this issue is not simply about whether or not an oath needs to be taken by the circulators in front of the notary public. The circulator statute 253602 that sets out what is to happen as regards the circulators requires compliance with KSA 53501, which is the general statutory scheme for notaries. And notaries don't simply administer oaths. Rather, notaries also are to determine whether or not the person appearing before them is in fact the person that they claim to be. They're to place them under oath. They're to take an acknowledgement of them as to the matter to which they are subscribing their signature. And so to the extent that the district court claims that there is a basis to override the notary requirement of 53501 through the language of 53601, there isn't a basis to override it, perhaps other than as to the taking of an oath, but does not suspend in any way, shape, or form the other things that the notary is to do and the reason why a notary requirement is required under KSA 253602. I'll reserve the remainder of my time. Thank you, Your Honors.
Thank you, Counsel. Please.
Yes, Your Honor. May it please the court. Eric Steinley on behalf of the Appellees, Reno County, Kansas, and the Board of Commissioners in the county. I want to first summarize what our position is. The district court's decision that these protest petitions are valid, and that was its final judgment, that the protest petitions are valid, should be affirmed for two reasons. One, KSA 253602 does not apply. Alternatively, if it does, if your honors find that it does, then KSA 53601 provides that the circulator's signatures, swearing under penalty of perjury, that they witness the landowner's signatures is a valid substitute for signing before a notary. As an initial matter, however, I want to address this question about whether the county or frankly the interveners were required to cross appeal.
Mr. Steinle,
That was it.
Mr. Steinle, may I ask you a quick question?
Absolutely.
If we do not view 25-3602 in conjunction with 12-757, how are we to gauge and determine the proper protest petition contents or process? 12-757 tells us what the consequences are from a protest petition. But if we take 25-3602 out of the equation, how do we determine the adequacy of the contents of a protest petition? Where else would we find that information?
I believe that is in Reno County zoning regulation 20-102. Now, it mirrors the language of 757, but the point is nothing so sophisticated as 3602 is required. It simply requires that within 14 days after the date of the conclusion of the public hearing, pursuant to the publication notice, they file the landowners, not the electors, mind you, as mentioned in 3602, but the landowners affected. By the way, that's within 1,000 feet is the notice section, Your Honor.
Thank you.
Duly signed and acknowledged by the owners of record of 20% or more of the property. It doesn't have to take any particular form. It simply it would have to satisfy that regulation to indicate that I'm a landowner. It would have to be enough that the county could conclude that this person is in fact who they say they are, they're a landowner, and that they duly sign and acknowledge. It's not before Your Honors, but I can tell you that the process here, it was very extensive, where the county clerk and the county zoning officer goes through and has a spreadsheet, and they look at who got notice. Are these people within the notice? There is an entire evidentiary process. Obviously, none of that is before you because that was not a factual issue on appeal as to whether any of these particular protest petitions, and there were, I would say, hundreds of them or 100 of them. There were many protest petitions, not a single protest petition, but many signed by different landowners that all stated the language of their their legal description and that they protested this conditional use permit. I hope that answers your question.
It does.
I don't know that anywhere there is anything more specific than that, but I don't think that anything more specific is required than that.
Thank you.
Yes.
Counsel, I believe you are going to address this cross appeal issue, and I'd be interested in your take on that.
Well, certainly. First of all, you have to understand what was appealed from. Keep in mind that the issue before the court was whether or not the protest petitions were valid. The plaintiffs, appellants, raised a number of issues, one of which was this question of whether KSA 3602 applies and requires some sort of notary. The appellants argued that the protest petitions did not comply with Kansas law. We argued that they did. The district court, in its final journal entry, which was drafted by the appellants, said that the unnotarized signatures of the circulators substantially complied with Kansas law. And it also says, quote, the unnotarized protest petitions complied with Kansas law. That is the judgment appealed from. It is not, we don't appeal from reasonings, and the court's reasoning may have been a little different. But the district court made no final ruling which was adverse to the county from which the county would want to appeal.
So we have this principle, it's not a doctrine, that we tend to apply with regard to cross appeals, and that is that we can take a look at decision or alternative reasoning to support the district court's decision if the district court didn't reach those questions. But here we have an instance where the district court did reach whether 253601 at SEC applies and ruled against you. And so how does that change our analysis, or does it?
I don't think that it does. I mean, because you have to square it with, and I think it's actually the Capers decision that was one of the first cases that's repeatedly cited. But I would cite to you Lacey versus Kansas Dental Board, 274 Can 1031 at page 1044. In that case, the court said a trial court's reason for its decision is immaterial if the ruling is correct for any reason. And the facts of that case were that a Dr. Lacey, who was a dentist, had been alleged by the board of Kansas Dental Board to have violated the Practice Act by essentially permitting franchise practice of dentistry. Essentially, he wasn't present more than 50% of the time in one of the offices or several of the offices where he was practicing dentistry. In that case, and I think it's very significant, the Kansas Supreme Court held that the district court used the wrong section of the same statute, in reaching its conclusion, but that a different section of the same statute before the court on appeal justified the court's decision. And so it held that a different part of the same statute was right, and the court was right for the wrong reason. What is before you is not something collateral to the main issue. Your Honor, Judge Warner, you pointed out, and you're absolutely correct, I have it in my notes here to point out to you had you not recognized it. Even the appellants make the argument that KSA 3602 applies in their opening brief at pages 9 to 12. They're arguing for the application of this statute. The application and interpretation of the statute is the central question on this appeal. And it's also essentially what the plaintiffs and the appellants want you to do is to ignore the entirety of the statute, even though as a matter of law, you must look at the entirety of the statute and the act in interpreting it and applying it. They want to limit you by this cross appeal red herring to only look at a portion of that statute and ignore the remainder, because even though the district court reached the correct ruling for the incorrect reason.
Counselor, could we take a look at 253601F?
Yes.
I have, as I mentioned to opposing counsel, I think that the court's taken a look at this, and we've looked at some other, to see whether there were any other instances where this petition statute might apply to an instance where it doesn't go to the electorate. And in 3601F, there are some explicit exceptions, which includes a grand jury petition, which does not go to the electorate. Does that indicate that 253601 and its following statutory sections is actually broader than what you have argued to this point?
Well, I guess, Your Honor, the answer to that question is I don't know whether it applies beyond something else, but it doesn't apply to this. And for that, what I would suggest to you, at least at a minimum, aside from the language of looking at 3602, because I don't know how anyone could look at 3602 and conclude that it applies to a protest petition on a conditional use permit. It's impossible. As a matter of fact, I mean, I think substantial compliance is also a red herring, but it begs for substantial compliance because you essentially must ignore most of 3602 in order to apply it to the conditional use permit circumstance. But having said that, I think that as it applies as to the conditional use permit issue, if you look at 3601D, when any other statute imposes specific requirements which are different from the requirements imposed by 3601, the provisions of the specific statute shall control. Now, it doesn't require that it that it be as detailed as 3602. It simply requires that if there is another process, that process applies. And here we have another process.
And counsel, how much of that process applies? My question is it a wholesale substitution, or is it a kind of a gap filling process?
In my view, I cannot ignore the other language in 3602, and I just simply cannot see how 3601 and 3602 apply to a protest petition and a conditional use permit situation. If attempting to make any sense of the language at all, you have to wholesale cut most of 3602 in order to conclude that it would apply here. And let me give you an example. If we can look at 3602, for example, and of course the language is mandatory. Each petition shall consist of one or more documents. And B, 3602B, unless otherwise specifically required, each petition shall state the question which petitioners seek to bring to an election. Well, that doesn't apply to this situation. Name the taxing subdivision or other political subdivision in which an election is sought to be held. That doesn't apply to conditional use permits. Contain the following recital that includes this language. I am a registered elector of the state of Kansas. What if none of the landowners in this case were registered electors of the state of Kansas? Would that then mean that none of them could protest the conditional use permit in this case? And then, of course, 4, which is the only section of KSA 253602 that the appellants want the court to focus on, talks about circulators and the verification upon oath or affirmation. So I cannot divorce I cannot tell you that 3601 doesn't apply to anything beyond elections. I don't know the answer to that because that question is not in front of us. That's not the question before this court. What I can tell this court in this case is that it doesn't apply to the protest of a conditional use permit, which would then trigger the requirement of a 3/4 vote, in this course, unanimity.
Counsel, I've allowed you to exceed your time a little bit with our questions, but I'll give you a minute to wrap up.
Thank you, Your Honor. I would point out that the 2 cases, Your Honor, in the Cook versus Gillespie and Reinecker versus Board, and going back again to this question of whether we had to cross appeal, those cases required different factual determinations. They were different collateral questions. There are no cases that I can find where the appellants raised the question of the interpretation and construction of a statute on appeal, and that the other side is prohibited from arguing that the court should look at the entirety of the statute and determine whether it applies, how do you interpret and construe, and whether to apply the statute in this circumstance. I can find no cases where that issue is not properly before the court because someone didn't appeal the court's reasoning as opposed to its final judgment. With that, I would yield my time and we'd rest on the remainder of our the issues. These issues have been adequately, I think, addressed in our brief, and we'd refer you to our brief.
Mr. Hughes?
Thank you, Your Honor. May it please the court, Patrick Hughes for the interveners. I would like to address basically 3 procedural issues. I would like to address this question of cross appeal, the question of invited error to begin with. The cross appeal issue, we have to be able to, first of all, we recognize that the cross appeal issue arises from a statute dealing with the right to cross appeal. And there's another statute that the legislature has also provided, which is the harmless error statute. And we need to figure out how do those interrelate? Because the legislature has told us that unless justice requires otherwise, no error by the court is grounds for vacating, modifying, or otherwise disturbing a judgment or an order. At every stage of the proceeding, the court must disregard all errors and defects that don't affect any party's substantive rights. What the appellants are arguing is that they're entitled to, even if the statute doesn't apply, to invalidate the protest petition. Well, justice does not require that the protest petition be invalidated by a statute that doesn't apply to the protest petition. So the harmless error statute tells us, the legislature is telling us, the court can look at this question regardless of whether there is a cross appeal.
Counsel, I agree with you that in some respects, those two doctrines are in tension. But my question is, I mean, cross appeal goes to the jurisdiction of the court to consider the issue at all, right? So those are really two different, they're related, but they're two different questions, right?
Well, they're not. It's exactly the reason it's important to look closely at the cross appeal. But clearly, the statute that we've looked at for harmless error is giving the court the direction, the power to look and say, is this if this doesn't affect someone's rights, then the court can say this is a harmless error. So that's not a cross appeal issue. The court has the jurisdiction there. But let's look at the cross appeal issue in more detail, because the question before the court is actually this: does the failure to involve a notary result in the protest petition being invalid? That question cannot be addressed without looking at the subsidiary predicate question of whether the election petition statute applies to the zoning protested issue. The issue of whether the statute applies is part and parcel of the appellant's argument. It's not a separate independent question from whether the notary is necessary for this protest petition to be valid. And there is no sound jurisprudential basis to conclude that where the appellant's argument is a chain of reasoning, the appellees have to cross appeal in order for this court to have the power to take note that there's a missing link in that chain of reasoning. Let's think about what would happen if the appellants were right. If the appellants were right, the appellate court could be forced by the absence of a cross appeal to decide Alice in Wonderland questions that have no relevance to the real world. The plaintiff's argument is like arguing that if they present to this court the question of whether the moon is made of Swiss cheese, after the trial court announced that it was made of cheddar, this court has no jurisdiction in the absence of a cross appeal to decide the dispute based on the fact that the moon isn't made of cheese at all. The mandatory cross appeal rule is about this issue. It's about when the appellee is seeking review of a decision or a ruling that is separate from the decision or the ruling that the appellant is seeking to have reviewed. So when the appellee had a motion to dismiss that was denied, as in James versus City of Pittsburgh or Cook, or a summary judgment motion that was denied, or a ruling on the admission of evidence that was denied. But here, the decision being reviewed is the entry of judgment and the denial of the plaintiff's motion for summary judgment. The appellees aren't challenging the denial of the plaintiff's motion for summary judgment or the entry of judgment. There was no separate decision or ruling that we're challenging. So because the rule we're looking at, the cross appeal rule is 2103H, it talks about referring to rulings and decisions, not another term of art that the Code of Civil Procedure also uses, which is conclusions of law. Here, what we're talking about are conclusions of law of the district court within a decision. That is not within the scope of what 2103H is saying a cross appeal is needed for. So the cross appeal.
Can I ask you a quick detour question? And this has been something that has been, I've been thinking about. I've been wondering, 12757 doesn't mention circulators.
Right.
But these protest petitions that were filed included circulator signatures. And if your co-counsel is correct that 12757 controls here, then why do these protest petitions even have circulator signature blocks on them at all?
That's a great question. And in fact, the form that the county promulgates doesn't have a circulator signature line on it. But I was aware that Deffenbaugh was out there as a case I thought was wrongly decided. But I thought rather than getting into that issue and having to litigate it, why don't we go ahead and address it along with the substitution that's allowed for unsworn declarations and get rid of that whole question from this. That's the history of why it's there in this form. The next issue that I wanted to talk about is invited error, because in this case, the court made 3 decisions or rulings, and all of them were rulings on motions that were filed by the plaintiffs. A ruling denying the plaintiff's motion for partial summary judgment, a ruling denying the plaintiff's motion for the findings that would be needed to take an interlocutory appeal from that denial of summary judgment, and a ruling in the form of the final order on the plaintiff's motion to dismiss the plaintiff's remaining claims and enter judgment against the plaintiffs on the other claim. The plaintiff's motion had explicitly requested, quote, that the court enter summary judgment in favor of defendants. Now, after the first of those 2 motions were denied, the plaintiffs had 2 options. They could wait for the defendant or for the interveners, as I planned to do, to file our own motion for summary judgment. And then the plaintiffs could have argued to the trial court that the denial of their motion for partial summary judgment had been the result of the error that they're arguing to this court, and that the error should not be perpetuated. That's not the choice they made. Instead, they asked the court to do the opposite, to leave that alleged error in place in its final order. They now ask this court to reverse that final order because of the alleged error that the plaintiffs themselves asked the trial court invited error, fully believing that the journal entry they themselves drafted was erroneous. They asked the trial court to sign it. Their justification is that they wanted to manufacture appellate jurisdiction that the trial court had denied them. Well, that's irrelevant. The invited error rule doesn't have an exception for when the invitation to error is part of a strategy to bypass the district court that is leaning against you when you want to get immediate appellate review.
Now, counsel, this is a little bit different because the plaintiffs here didn't ask for the district court to rule against them, right? They merely dismissed the remaining claims in the petition that would have allowed the case to perpetuate.
That's not true, because there had been no defendants. The motion had been the plaintiff's motion for partial summary judgment, which was denied by the court. If all the plaintiffs had done at that point was to dismiss the remaining claims, that wouldn't have made a judgment final against the defendants. The defendant still needed to come to the court and say, okay, we are asking for judgment in our favor. It remained interlocutory. It would have remained interlocutory, that question, undecided, if all that had happened was the dismissal of the remaining claims. And so what we would have done is we would have filed a motion for summary judgment, and the court would have then either said, I'm going to stick with my reasoning when I denied their motion, or the court would have said, you know, I'm going to reconsider that in light of Mr. Sears' arguments. But what happened is the plaintiffs deprived the district court of that power by saying, okay, we're going to ask you, district court, to enter judgment against us. That was what they asked for in their motion. It's really no different than if the plaintiffs had filed a motion to transfer this appeal to the Kansas Supreme Court, which was denied, and then in order to try to reach the Kansas Supreme Court more swiftly, had filed a motion in this court asking this court to just rule against them so they could file a petition for review.
And so I think about this in terms of, say, a motion under Rule 254B, where you've got a decision that's been rendered, and then at some point later on, the person who that decision has been rendered adverse to asks the district court to enter a final judgment on the merits for purposes of appeal. How is that any different from what's happened here? We do that all the time.
Because if I had filed a motion to enter judgment based on what the court had already ruled, then the plaintiffs would have had the opportunity, and in fact the duty, to object to that motion and give the court there the same arguments they're giving the court in their brief. They didn't do that. The district court relied on some cases that only on appeal do the appellants now say, oh, district court, you read those cases wrong. Well, they had an obligation to object to an entry of judgment on the basis that those cases the court was relying on was wrong. They didn't do that. Instead, once the court had committed what they claimed to be error in how it read those cases, they said, perpetuate that error. We want you to go ahead and enter an order based on what we think is erroneous, that we didn't explain to you why we thought was erroneous because you hadn't ruled that way yet. That is the whole reason why the issue is open, is because we didn't ask for a judgment. The defendants and the interveners merely were objecting to the request of the plaintiffs for judgment. Now, on our motion for summary judgment, we may well have, and probably would have, well, in fact, I know, would have approached the reasons for granting summary judgment for us differently than the court had approached its denial of summary judgment to the plaintiffs. Because frankly, the substantial compliance is not really the right term to use for what we have. We have, if the statute applies, we have absolute compliance because we've got a substitution of the unsworn statement. But nevertheless, we would have revisited the question of is the real reason you ought to be deciding this case, the real basis for it, if the statute doesn't apply at all. So they've circumvented that whole process where the district court has the opportunity to decide, am I going to make this a final ruling, which the court hadn't decided to do based on this theory, by agreeing that they're not going to object to that and asking the district court not to revisit it. So they've invited the error that they're complaining about. The third question, I guess, is of procedure here that I want to talk about is one that I guess maybe isn't addressed all that often, but what does the last line look like in the mandate? And what am I talking about? Well, if this court decides that there's not substantial compliance, if the court reverses the district court, then what is it that ought to happen next? What the plaintiffs asked the district court to do was to grant them judgment directing the defendants to approve the application for the conditional use, and upon proper application to approve other permits as necessary to construct the proposed development. Even if the trial court's decision were reversed, though, there's an open question that we haven't litigated of what would be the proper relief. The 2-1 vote does not make the conditional use permit effective as a final decision under the Reno County Code. It's not effective until publication adopting the resolution. So the county commission retains jurisdiction to revote. The county commission voted in the context of understanding that the protest petitions were valid and therefore a single vote against the application could defeat it. If that's not true, the matter ought to be sent back to the county commission to vote based on a correct understanding of the impact of the reverses. It should be remanded to the district court. But there's another wrinkle in this question, and that is, what does the court really have, the Court of Appeals really have the power to do under the notice of appeal? Because this court appears not to have jurisdiction to consider both issues that the appellants try to argue. One issue they want to argue is, did the trial court err in granting summary judgment to the defendants? I think the court has jurisdiction under the notice of appeal for that. The second is, did the trial court err in denying their motion for summary judgment? Well, the notice of appeal is oddly worded in this respect. It identifies the judgments that are appealed from as being the journal entry of judgment that the court filed on September 14th, which was the final order. And it identifies the journal entry denying plaintiff's motion for partial summary judgment as incorporated by reference in that.
Mr. Hughes, I've allowed you to exceed your time, so I'll give you a moment to wrap it up.
Okay. My point is simply that the notice of appeal appears to only be appealing from, telling us it's appealing from the denial of the motion for summary judgment only to the extent it's incorporated in the final order, which is the order that does nothing more than grant judgment to the defendants. So I think this court's power is to reverse that order, but a remand would be necessary. Thank you.
Thank you, counsel. Mr. Sear, your rebuttal time. I think you're muted. I have you as muted. Have we done something to muting?
on the screen. Okay.
There you go.
Your Honor, there's a command that comes on the screen that says you have to hit a key or wait 30 seconds. I don't have any keys at this end to hit, so I apologize for the delay there.
That's no problem. It's just part of the technology. I didn't know what was causing the issue, so you may proceed.
All right, Your Honor. The appellees are inviting this court to make jurisdictional error in this case. It simply is not the law of the state of Kansas that if you say the district court was right for the wrong reason, that gives you carte blanche to raise issues for which the appellees never filed notices of cross appeal. That's simply wrong. Now, to give you an example of the adverse rulings that were made against the appellees en route to the court entering judgment for the appellees and against the plaintiffs. First of all, the appellees claimed that the plaintiffs had not properly perfected their appeal to the district court. The district court ruled against them on that issue. No cross appeal was filed. The district court ruled against the appellees when the appellees argued that the protest provisions of 12-757 didn't apply. The appellees didn't take a cross appeal from that adverse ruling. The district court ruled that the circulator statutes apply to a zoning protest petition. That was an adverse ruling against the arguments made by the appellees. No cross appeal was filed as to that. Mr. Hughes specifically argued in the district court that the person signing as circulators weren't circulators. That was ruled against Mr. Hughes's clients. That's an adverse ruling of the district court for which no cross appeal was filed. Mr. Hughes argued on behalf of the interveners that there were controverted issues of material fact that precluded a grant of summary judgment. The judge ruled against Mr. Hughes and his clients on that matter, and yet in this court, Mr. Hughes attempts to argue that there are controverted issues of material fact without having filed a notice of cross appeal. All of these are adverse rulings, and the most specific one is that the circulator statutes apply. If you don't file
I want to talk about that question. So let's presume that the circulator statutes apply. Let's presume that we're bound by that determination. Then why is it that 3601D does not, as your opposing counsel have argued, say that the more specific statute of 12757 controls here?
Your Honor, both 3601 and 3602 provide for language and circumstances that are to apply unless otherwise specifically required. The otherwise specifically required triggers going back to KSA 12757F, which is the procedure for protest petitions. So where 757F provides direction as to how what the protest petition is to say and so forth, and when and how it's to be filed, 3601 and 3602 apply by reference 757F. So we have what we need. And for example, there's
those lines in 3602. I mean, how much of that information has to be included, in your view, in order for a protest petition under 12757 to be valid?
all that the county clerk needs to be in a position to determine when the protest petitions are filed is what is being protested. And the protest petition says that they are protesting the application for the conditional use permit. So that is the connect the dots there, that the protest petition relates specifically to any action by the county commission to approve a resolution or an ordinance granting the conditional use permit. There's no confusion.
What is the circulator signature not superfluous?
Well, Your Honor, if if there was not a statutory requirement that the circulator do certain things, then it would be superfluous. But we're not to ignore requirements put in place by the legislature. The legislature.
I guess that's what I think we're talking in circles a little bit here, but that's what I'm trying to figure out. I'm trying to figure out how much of 757 supplants the requirements in 3601 and 3602 because it is more specific and relates to protest petitions, and how much of 3602 remains.
Well, Your Honor, let's look at it this way. Let's look at it from the perspective of what is the county clerk to do or the county commission to do when they get a protest petition. Well, the county clerk, has to be advised in some way, shape, or form that this is a protest petition so that the county clerk knows what to do with these papers when they come in. Well, the form, as drafted by Mr. Hughes, specifically set out what it was that was being protested and who was filing it. A circulator was filing it. Well, again, as confessed here by Mr. Hughes in our argument, that signature block and attestation for the circulator was put there not because of anything that just fell out of the sky. It was put there because of 253602. Now, if there is no circulator and the protester is filing the petition, the county clerk, if they choose to inquire as to what's going on here, they could ask the petitioner, is this your signature and do you own the property that's referenced here? There isn't a requirement under the statute that the county clerk do that, but that's what a county clerk could do. However, when someone that is disconnected from the protest petition delivers it to the county clerk, that is, I'm not the protester, I'm someone that has gathered these protest petitions up and I'm delivering them to the county clerk, that is certainly an issue that the legislature could have wanted by enacting 3601 and 3602 to require some particular proof that the circulator is acting pursuant to the statute and that the circulator has witnessed the signature of the protester.
But is there a requirement that the circulator or whoever is filing, whether it be a circulator or a landowner, is there a requirement that they file that in person?
The statute does not refer to that, as to, for example, whether they could be mailed, whether a delivery person could bring them in, but it's certain 3602 certainly requires that the circulator have witnessed the signature of the protester. And certainly the legislature is within its rational basis to think that, if we're going to have somebody filing something for somebody else, there ought to be some requirement that this is a true and accurate signature of the protester that has the right to protest, as compared to a circulator that doesn't have a right to protest anything. So requiring that sort of attestation by the circulator or requiring the formalities of the circulator appearing in front of a notary public, as far as adding formality and some layers of proof to the process, would certainly be within the rights of the legislature, thinking that we're going to make this, a formal procedure in order to try to avoid there being fraudulent filings of protest petitions. So in this case, if the statute applies, then we've got to apply the requirements. And substantial compliance simply doesn't apply in this case. For example, how can the interveners claim that they attempted to substantially comply with a statute that they say doesn't apply? That's nonsense. Also, Mr. Hughes argued in the district court that the circulators were not circulators, even though they signed under penalty of perjury a statement that they were circulators. Again, pure nonsense.
Those arguments, however, are red herrings if we decide that substantial compliance is the correct standard. Then we just look to the substance of the petitions and whether the substance of that petition substantially complies with the statutory requirements, right?
No, Your Honor, I don't think that's right. The statute requires that the circulator comply with the requirements of 53501 et sec. They complied in no way with 53501 et sec. So you can't substantially comply with a requirement that, first of all, you don't attempt to satisfy, and second of all, you don't satisfy it at all. Now, the issue of KSA 53601 and whether or not that did away with a requirement that an oath be administered by the notary, that's an issue that perhaps this court can reach. But if you read 53601 as writing out the oath requirement of 53501 et sec, it doesn't write out the requirement that the person still appear before a notary and meet the other notary requirements of 502 and 503, that there be proof that they are the person, that they are the circulator, and that this is their signature. So there are requirements of 53501 other than the oath. And as this court ruled in the double S case, the only reason for the enactment of 53601 to get around failure of notaries to put the affiant under oath, which goes back to State v. Kemp, is limited to the oath requirement of a notary, not to any other requirements under the notary statute. And I would point out that 53601 specifically says that nothing in that statute diminishes or invalidates the recognition accorded to notarial acts by other laws of this state. And in this instance, the other rules of this state is 253602 that requires the circulators to appear before the notary and the notary to satisfy all of the requirements in order to attach their notarial signature and seal, even if under 53601, the failure to administer an oath can be ignored. So,
Counsel, I've allowed you to exceed your time here a little bit. I'll give you a chance to wrap up unless the judges have other questions.
Your Honors, I appreciate the time provided today and your attention. Again, there is only a very narrow issue before this court, and you simply cannot determine that anyone attempted to or did substantially comply with a statute that they claim doesn't apply to them and that they made no attempt to satisfy. Thank you.
Thank you, counsel. You've presented a rather interesting issue for us to resolve. We'll take the matter under advisement and issue an opinion as quickly as time allows. Have a great day. With this, court is adjourned.